This will be the third video in weeks 5 to 6. It's a screenshot video. This picks up where we left off on this posting 7. We had a video on the topic of criminal liability for the conduct of another, and we're getting to the second part of that posting, which is anticipatory offenses. And what we see in the criminal law is sometimes people are not liable for what I'm going to call the target offense itself. We've seen the Gotti be responsible for the murders committed by Gravano. We've seen the arsonist who was hanging out in Fort Lauderdale with his girlfriend be responsible for the arson that was committed by the guy who burnt the building down in Buffalo. Here, however, when we talk about anticipatory offenses, there is something lacking to permit liability to be imposed on a person under Section 20. But what they did, at least in the estimation of the criminal law, is wrongful enough to have the person be charged with some other offense that's not as severe as the target offense, but nevertheless is going to result in the imposition of criminal liability and possibly a jail sentence, etc. So we have 4 anticipatory offenses: criminal solicitation, criminal facilitation, conspiracy, and attempt. So let's go to the first one, criminal solicitation. And I can remember once watching, I should be embarrassed to say this, but watching a cringy reality type of TV show where a woman was sitting in the pickup truck, and behind the wheel was a person who she thought was a hitman, but in actuality the person was an undercover cop. And there was audio and video, and basically she offered to pay this person who she thought was a hitman a certain amount of money to kill her husband. And I think one of the reasons I remember the video was that at the very end she almost was asking with a nervous giggle that I know you're going to kill him for me, but when you're doing that, please try not to hurt him too much, which I thought was a wonderful wonderful thing. I guess she had a good heart. In any event, she then gets arrested for whatever that jurisdiction's version is of criminal solicitation. Under New York law, that would have been her crime. Because what she did, if we look at the definition, she had the intent that a crime be committed, namely murder, and she asked another person to commit the crime. Obviously, the undercover cop didn't go out and kill her husband, so she wouldn't be liable for murder in the style of John Gotti, but by asking another person to commit the murder with the intent that it be committed, she clearly is guilty of criminal solicitation. The next anticipatory offense is criminal facilitation. And here, the defendant is helping someone commit a crime, though the defendant really doesn't care if they commit the crime or not. We've got a 3-part definition. They believe it probable. So we go from intent here to knowledge, really believing it probable that they're rendering aid to another person who intends to commit a crime, and they then engage in conduct which provides such person with means or opportunity for commission of the crime, and 3, which in fact aids such person to commit the crime. So the example I've come up with is we've got our defendant who is a lab technician, and he has a certain kind of poison. You can say I've been watching too much television during the pandemic. He's approached by A, who offers to buy a dose of the poison so long as it's lethal enough to kill another human being. and during his interactions with the defendant, A says that he's not getting along with her spouse. So the defendant then sells the dose of poison lethal enough to kill someone for $500 to A, and then A, in grand style, uses the poison to kill their spouse. In this case, defendant didn't have any intent that A kill the spouse. The defendant just wanted to get $500 for the dose of poison. But nevertheless, the defendant's going to be guilty of something, and what he's going to be guilty of is criminal facilitation because he knew or believed it probable that he was assisting another person who wished to engage in criminal conduct. He gave the person the means or opportunity to commit the murder, namely the poison, and then A, who I'm certain I was on the hook for murder, in fact used the poison to commit the crime. So that's an example of criminal facilitation. Let me just, it's not in the posting, but let me offer you a counter example where I don't think we would see criminal facilitation. Let's assume I go into, what's one of these stores you can buy a gun? Cabela's, I think. Maybe I'll go buy a gun and some camouflage stuff to wear. I don't know. But I go into Cabela's, and I'm not being disrespectful to Cabela's. I don't want to get sued for defamation. But I go into Cabela's, and I go through the rigmarole, and to buy a gun. I think I could buy a shotgun there without much of a problem. I think they do a quick online background check. But I show my ID, etc. And as I'm purchasing the shotgun, I then am also buying ammunition for whatever particular type of shotgun I'm purchasing. And the salesperson, as salespersons do, just is making banner. And he said, well, you're buying this for personal protection or target shooting or whatever. And I say to him, well, I'm going to use this gun, and I'm going to shoot and kill my colleague, Joseph Kraninsky. Don't tell Mr. K that I'm using him as a victim in this hypothetical. And the salesperson thinks that I'm just a knucklehead with a very poor sense of humor, and he sells me the gun and the ammunition. I then drive to Mr. Kraninsky's house because I know where he lives, and I shoot him and kill him. Well, I'm certainly guilty of murder, but I don't think the salesperson is guilty of criminal facilitation, because under the circumstances, I don't think you could conclude that he really had reason to believe that I was intending to commit a crime, as opposed to I just was saying stupid things. So if that's the conclusion we reach, and I think that would be a fair conclusion, I don't think the salesperson is going to be guilty of criminal facilitation. Okay, let's get into our third anticipatory offense, conspiracy. And here we've got a person is guilty of conspiracy with intent that conduct constituting a crime be performed. He agrees with one or more persons to engage in or cause the performance of the conduct. There's another element in New York law that's required, and that is one of the parties to the agreement or one of the parties to the conspiracy must commit an overt act. And an overt act is some open act that furthers the conspiracy. And I have an example. You and I agree to rob a liquor store. And you buy masks for us to wear during the robbery, because I think it would be cool to sort of hide our identity. And both of us are guilty of conspiracy because we agreed with the intent that a crime be committed to commit a crime. And I also, as one of the conspirators, engaged in an overt act that further the conspiracy. And I flipped this because I said you buy the mask, I buy the mask. But the fact is, one of the conspirators buys a mask, and that's enough to have all of the conspirators held liable for conspiracy. But the state has to establish at least one of the conspirators committed an overt act. I remember once being involved in a drug conspiracy, not as a defendant, but as a lawyer. And it was a charged conspiracy, but what had happened is the state had all of these conversations that were wiretapped. That was back when they had these things called landlines. And all of these people were talking about how they were going to move cocaine into the Buffalo area and then sell it. And so you had a number of people charged with conspiracy, but all they had was proof of the agreement. They didn't have any proof of any of the defendants going out and actually doing something to further the conspiracy. Now, doing something doesn't necessarily need to be a crime in itself, like buying the mask certainly isn't a crime, but you've got to show something, and the government didn't allege any overt act, and so the charges were dismissed. Our last anticipatory offense is attempt. And of course, as I point out, nobody's charged just with attempt. It's got to be tagged onto a crime, so attempted robbery or attempted murder. And it's kind of interesting, but our definition of attempt in the New York Penal Law to me is somewhat ambiguous. It's defined as occurring when, with the intent to commit a crime, so far that's clear, the defendant engages in conduct which tends to effect, and effect in this version is with an E, meaning to bring about the commission of the crime. And so the question arises, how far must a defendant go in trying to commit a crime before it can be said that the defendant is guilty of the attempt to commit the crime? Obviously, if I shoot at you with a loaded gun and I miss, we don't have to worry about how my conduct tended to bring about the commission of the crime. But there's a different scenario that could present a greater problem. A wants to kill B and is found 200 yards from B's house with a loaded gun, with evidence independent of where the defendant's found that indicates his intent. In this case, the court found that the defendant did go far enough because he was in dangerous proximity to committing the crime. But let's assume that A was found 200 yards from B's house with a loaded gun, but there was no independent evidence that A wanted to kill B. Then I'm going to suggest there would be insufficient evidence to charge attempt. So that's going to end our look at the anticipatory offenses.